So many of us watched this from around the country and even around the world. We weren't there at the courthouse. Can you tell us what it was like at the courthouse? I mean, do you remember? Did you black out?
It was so my recollection is probably going to be a little different than Mr. Bott's. So we were in there. There was a status conference on the remaining clients, defendants, that weren't in the first trial. So So I was just, I was excited to see some of the young men that were initially with us. That Mr. Mender, Mr. Garlington, who I've known, and so and others. And so I was just kind of being nosy. Mr. Bosch was with me, and then the light went on from the jury room. And I never knew this because I usually don't sit in the courtroom waiting on a verdict. I'm usually doing something else.
Yeah.
And apparently there's different colors.
Okay.
So the light was blue, and one of the DAs who I'm friendly with says, "Oh, don't worry. Blue just means a jury question." I said, "Okay, well, we don't have a verdict. It's just a jury question." So the judge kind of ended the status conference for those other gentlemen. And, then all of a sudden we took center stage, and she said, "We have a verdict. We have 2 verdicts." Wow. And I was just like, "What?"
Yeah.
And, I just wasn't expecting that, because I was expecting them to ask us to play some video or something again. So I was like, okay. So then I looked at Shannon, and I was like, I guess we have a verdict, Shannon. And then she read it so quickly for Mr. Kendrick.
Yeah, it was amazing.
And then the date thing, I figured that out pretty quickly. I was like, wait a second, they found Mr. Kendrick not guilty yesterday, and I've noticed them kind of focusing on Shannon, but I was thinking there's no way they could have different verdicts for the 2015 case.
Yeah.
So I felt good about that. And then the judge said, "We have a guilty verdict on count 64. And I said, okay. And I was like 90% sure. My mind just left for a minute about what count 64 was. Of course, I knew it, but it just wasn't computing at that moment. So then if you look, I went over to Doug and I said, you can't hear it, but I said, "Doug, count 64 is the gun charge, right?" And he was like, "Yeah." And he was happy, and he said, "I think so." And I was like, okay. So, but it worked out, and it was kind of a blackout moment. What do you remember, Mr. Botts?
Oh, I got
it. The judge said, "We have a guilty on the gun charge, count 64, and not guilty on all the other charges." That's exactly what she said. And so that was, to me, a major win.
Did you know at that moment? Because my mind just kind of left. Wasn't 100%. You knew. Okay.
And I said, whoa, because I was expecting, once you hear guilty, you say, oh, God, what's the next thing going to be? What's the other charge? But she just immediately followed that with a not guilty on all other charges, which was how the jury wrote the verdict. And so immediately I began to think, oh, God, he's going to get the maximum on the gun charge.
Mm-hmm.
State was asking to treat him as a recidivist, and the judge said, well, I have to give him the maximum as a recidivist. However, I can probate some of it.
Yes.
And so instead, she said, I'll give you the 10 years, which is the maximum, to serve 2 years, credit for time served, which he'd already served. And Max, before that verdict was reached, he asked to approached and said, if you're going to give him time, it's going to be a death sentence. You've got to give him, you got to do something. But then he said he noticed on the podium a sentencing manual that she had in front of her. And so he felt pretty good, and she kind of smiled and sent us back down for the sentencing. So it was actually a surprise all the way around for all of us. But probably the prosecution was more surprised than we were.
Well, I'll say this. just to put it in perspective, I had a feeling after when I went back, I had a feeling things were going to work out. But I want the public to understand, and I said this to the press the day of the verdict and sentencing. You as judges, typically, when you go to trial, their just instinct is to give the maximum. Like, you dared challenge the state. You know, some people call it a trial tax, and everyone says there's no trial tax, but, you know, in my experience, there is one.
Yeah.
So Judge Whitaker was so thoughtful in not just saying, okay, maximum 10 years, you take your 10 years. And I just thank her for that. And I give her so much credit for, you know, understanding the totality of this case and understanding that the jury completely rebuked all those other charges. And we're just dealing with one gun charge, and that was the appropriate sentence. Because, you know, other judges may have said, well, he was charged with all these other things, so I'm giving him the maximum. And that's not what she did. And we are so thankful for that. And that was not the easy thing to do.
And it sounded like for the people at home, there was a discussion up at the bench that we didn't see on camera, but that made you feel a little bit better going into the sentencing that she wasn't going to do that, right? Wasn't going to get the max. Can we be clear on that? This was like a
I'm not going to go into the specifics about what was said. I mean, it's going to be on a transcript, I'd imagine, because it was on the record. But I left that discussion. Let's just put it this way. I went back. I elbowed Shannon in the left ribs, as I'm prone to do. And I said, Shannon, it's going to be okay.
Yeah. Yeah. Wow. And when you said you told the judge that any kind of sentence could be a death sentence for him, is that just because of the safety and the conditions of the jail or the prison? Or is it also because he had been acquitted of these charges and that could kind of put a mark on him in prison? Can you explain that?
At trial, we heard about 2 different attempts on his life. We also know that he was stabbed in the jail. We were never seriously considering a plea. But the understanding always, if there was going to be a plea, there was going to be facilitation from different agencies to make sure special accommodations were made for Shannon. So my concern was, if we're going to do the sentencing today, and it's going to be a sentence that's going to lead to incarceration, we can't do it today because we have to get everything in place to facilitate that and keep him safe. But after that discussion, I felt like I was worrying about something I didn't need to worry about. Yeah. And I just need to sit down and let the sentence happen.
Because it seems pretty common in at least southern states that you have this kind of sentencing right after the verdict. Is that true? Is that pretty standard in Georgia State Court that you see that? Or is there usually prep time because you have issues that you want to argue about, like you were saying?
No, it's very common to do it right after. I'm trying to think. There may have been a couple cases where it hasn't happened immediately, but that I can think of, but it's definitely 99.9. It's right afterwards.